Okay, so good morning everyone, and apologies for the slight technical issue there. We do sometimes get gremlins in the machine which have to be found with a stick and removed from the process, which has now been done. So we are talking about extensions of time and proving delay with Jack Swadling, who is an associate at Silver Shemmings Ash. So basically, Jack, I'm going to hand over the floor to you. If anyone has any questions for Jack, if you could submit them via the Q&A panel in your toolbar, and then at the end of the session, when Jack's finished his presentation, I'll ask him the questions, and I'm sure he'll do his utmost to give you the best answer possible. So Jack, I'll hand over to you, and we'll see you at the other end of the presentation.
Thank you very much, Julie, and thank you for everyone for joining us this morning. Today I have the rather daunting task of discussing the law of delay and extensions of time under construction contracts. Just by way of introduction, I'm an associate solicitor in the construction team at Silver Shemmings Ash, mostly working in construction disputes. And you have my contact details on the bottom there if you have any questions arising from matters we'll be discussing today. So here's the agenda of topics I intend to discuss. As you'll probably appreciate, it's a huge area of law when discussing completion obligations, time and delay. And I fear I might be attempting here to fit a court into a pint pot. Apologies in advance if perhaps there might be a little bit too much content in the slides, but I hope that would be useful for some of you for reference. So first of all, we're going to be looking at first principles. I would imagine the issues you'll be facing day to day are issues under the standard forms of contract that have been drafted to address the problems that delay causes at common law. But I think it's certainly worthy to start with these first principle issues and then to move on to the extension of time provisions under standard forms of contract, just to put the problems in some context. So first of all, we're going to be looking at the time obligation and completion obligation that works under a construction contract. So when looking at a construction contract, we can think of it as having three key elements. First of all, it's got to define what the scope of the works are. And so there is an agreement actually what work's going to be completed under it. Second, there needs to be a term that is going to define the time for the work. So how much time does the contractor have to complete it? And third, there needs to be a mechanism for defining the price. Now, if either time or money isn't defined, then what will happen is statute and common law will step in to imply a term into the contract to give it effect. So when we're thinking of the time obligation, there's actually two separate obligations that need to be thought of. First of all, the time obligation is the obligation of the contractor to complete the works by the completion date, which in a sense is an absolute requirement under the contract. And there is nothing in that obligation that specifies how the work needs to be completed by the contractor. At common law, if the contract makes no express provision for how the contractor is to progress the works, then the contractor may be able to say that they can progress the works however they see fit, get it all done in the last week rather than the preceding 3 months. So there is the time obligation, first of all. Second, there is what I've called the completion obligation. And this is the obligation on the contractor for how it progresses the works from the commencement date to the completion date. Under the JCT terminology, the contractor is under an obligation to carry out the work regularly and diligently. So that means that they will be carrying out the works in a regular fashion. Obviously, it's going to be very important to an employer that the work is carried out in a certain fashion if the contractor's work needs to be coordinated with other members of the team on site. And this is an important consideration when drafting amendments to contracts. So what happens if you don't complete by the completion date? So there is a breach of the time obligation. Now, if there is just a stipulation for time, or if there isn't a stipulation for time in the contract and the contractor has just a reasonable time to complete the works, then if the work is not completed by the completion date or otherwise within a reasonable time, the employer will have a claim in damages for its losses caused as a result of the delay to completion. And this claim in damages will be assessed applying the common law. So what's the difference in the employer's position but for not completing on the completion date? Plainly, for an employer, it's going to be a difficult task to prove what the extent of its losses are as a result of work not completing, or at least what the full extent of its losses are. This will be a difficult claim and a time-consuming claim to put together, and is not what they want to be faced with. It might be the case that in actual fact the employer has not suffered any loss at all due to the delay itself. But in those circumstances, the employer would still want a contract that imposes a disincentive on a contractor not to complete by the completion date. This is why a secondary obligation to the time obligation in the form of a liquidated damages clause is so important to an employer, and why it's so important for that liquidated damages entitlement to be maintained for the employer's security. And what the liquidated damages provision does is sets a fixed tariff of what the employer can claim in the event that the contractor fails to complete by the completion date, i.e. it breaches the time obligation under the contract. Some would say that the liquidated damages clause is actually the most important clause under the contract, so far as the employer would be concerned. So just quickly to go through these points, time of the essence. Where a completion date is not achieved, so the time obligation is breached, when we talk about time being of the essence of the contract, what we mean is that the completion date is a condition of the contract, and it would entitle the employer to treat the contract as discharged in the event that the contractor fails to complete on the completion date. So that would mean that non-completion was a repudiation of the contract that the employer was entitled to accept. Now, the standard rule is that the date for completion is not a condition of the contract. I think you would need some pretty clear and explicit wording if that's really what you were trying to achieve. The only key point to take out of this, I suppose, is it's not really an issue that poses great problems under the standard forms of contract, is that if you, in the usual course of events, if you do not complete by the completion date, it's a breach of contract, but it does not entitle the employer to treat the breach as a repudiation. However, the employer can take steps to make time of the essence of the contract if after the completion date it serves a notice seeking to make time of the essence. And I've included some notes here of the famous judgment of Denning in Rickards and Oppenheim. I think you can probably look at that in your own time. Okay, so time at large. Now, this is an important principle and is one that has received significant recent judicial scrutiny. Now, what's meant by time being put at large under a construction contract is that if the construction contract does not contain an extension of time clause, so a clause entitling the contractor more time to carry out its works under the contract, or if that clause does not provide the contractor with an entitlement to more time in the event of a certain act of prevention by the employer, then if the employer commits an act that, commits an act that prevents the completion of the works by the contractor, then that act of prevention is said to put time at large under the contract, and so the completion date in the contract is discharged, and the contractor will instead only be obliged to complete the work within a reasonable amount of time. And this really is a very bad situation for the employer to find themselves in, because of course a completion date is important. It gives certainty to the employer when the works should be completed by, but not only that, but if time is put at large, what happens is the liquidated damages clause is displaced, and the employers will only be entitled to claim damages for losses caused as a result of the works not being completed within a reasonable time, however that's to be defined. But that's not a situation that the employer wants to find themselves in. So time at large is often an issue that is raised by a contractor claiming that the contract does not provide it with the entitlement to an extension of time due to an act of prevention by the employer, so setting time at large and putting it in a rather better position. So the time at large, this is directly linked to what's called the prevention principle. This rule is based on the notion that a promisee cannot insist upon the performance of an obligation which it has, when it has prevented the promisor from performing, and reflects the fact that the fixed completion date gives rise to both an obligation on the contractor to complete within that time and a right on his part to have the time available to complete the work. So where there is a completion date, it is true there is the time obligation on the part of the contractor to complete the work within that time, but directly associated with the obligation on the contractor is the obligation on the employer to give the contractor time to complete the work as agreed under the contract. And if it prevents it from allowing that time, then the contractor should not be held to the completion date. So, as mentioned before, consequences of the prevention principle. Where the prevention principles applies, it will have the following significant consequences. The employer will be unable to claim liquidated damages because the fixed completion date having become irrelevant. There would be no date from which liquidated damages can be assessed. For the employer also, as mentioned, its claim for arising from the contractor's failure to complete the works within a reasonable time, which is when the completion date will be reset to if the works have been prevented, will be limited to what it can prove its losses are, rather than the fixed tariff under the liquidated damages provision. Third, the employer will be able to terminate the contract only by making time of the essence of the outstanding obligation. So this is what we were talking about making time of the essence. But this again depends on whether or not the contractor is in unreasonable delay, i.e. it fails to complete within a reasonable time. And completion within a reasonable time, it's fair to say, is a pretty nebulous concept. Or at least it needs to be determined by a third party. So application of the prevention principle, I think it's with the prevention principle, it's been elevated in importance by the decision in Peake and McKinney. I'm not sure I put that down here, but this is what I was talking about when I mentioned that contractors will also often look to the extension of time provisions to see whether there are gaps and whether something that the employer has done does not entitle them to an extension of time under the extension of time provision, so can be said to be an act of prevention which puts time at large under the contract. As mentioned here, the strict application of the prevention principle is being subject to criticism, and that's just because it's so absolute. A very minor act of prevention that does not provide entitlement under the extension of time provisions to the contractor can put time at large and really put the employer in a very difficult position. So when doesn't the prevention principle apply? What are the exceptions? Well, first of all, would be where an employer asks the contractor to carry out extra work or instructs a variation, and the contractor expressly agrees to carry out that work and to complete it along with everything else it needs to do by the completion date. So it's agreed that this instruction isn't prevention at the time. But as mentioned, secondly, and most importantly, time will not be put at large under the prevention principle if the contract contains an extension of time provision which provides a mechanism to the contractor to seek additional time as a result of whatever action has been taken by the employer that has delayed the work. And you would often see, well, you would see in the JCT form where it lists relevant events, that the wording of the provisions granting the right of a contractor to seek an extension of time are drafted in quite broad terms, just for the very reason that unless it is, then it risks that certain actions of the employer might fall between the gaps and potentially lead to difficult arguments about whether or not time has been put at large. I've included a brief note here on the decision in Multiplex and Honeywell, which was one of the significant, well, one of the many significant pieces of litigation arising from the construction of Wembley Stadium. And these are the comments of Justice Jackson, who I think at the time was head of the TCC. And the relevance of this is, what is the position of the contractor if there is an extension of time provision, but they fail to avail themselves of the additional time that they would be entitled to under it due to failure to comply with the notice? And his judgment in this was quite clear. A party to a contract cannot rely upon preventing the contract of the other party where it failed to exercise a contractual right which would have negated the effect of that preventing conduct. I.e., if there is an entitlement to an extension of time under the contract, then it is for the contractor to claim that entitlement, and if it doesn't, it's not going to put time at large. So, careful scrutiny of the extension of time provisions is warranted. Brief note here on why contracts include extension of time provisions. So, first, they enable the refixing of the original completion date, where delay to the completion of the works has been caused by matters which are the employer's responsibility, in order for the employer to retain the benefit of a completion date and entitlement to LADs. Second, extension of time provisions can be said to benefit the contractor in that they, if they obtain an extension of time, it would protect the contractor from a claim in general damages in respect of its failure to complete by the original completion date, and provide certainty in the event that it's inculpable delay. So it may well be the case that the liquidated damages rate that has been agreed has been carefully negotiated and capped in a way that wouldn't apply if the employer had a general a right to bring a claim in damages at common law for the failure to complete by the completion date, and this could potentially expose a contractor to greater liability. So third, extension of time provisions are a key part of the parties' agreement under a building contract as to how the risk of events causing delay and what their financial consequences will be, and how those risks are apportioned. It's often the case that extension of time provisions are subject to significant amendment, as I'm sure any of you who are used to receiving schedules of amendments from employers will have seen. And this process of amending these terms is so that risk of different things happening are allocated to the parties in a way that is agreeable between them. In certain instances, it might be the contractor's view that the employer is looking to push more of the risk onto the contractor for things that perhaps should be neutral events, so events that entitle additional time but not additional money. This is why amendments to the extension of time provisions are important. So, quick note on the JCT form, and I'm sure many of you will be familiar with this. Matters, causes of delay to the completion of the works are agreed to entitle the contractor, that are agreed to entitle the contractor to an extension of time of the completion date, called relevant events. Even when not looking at a JCT contract, I think these events would be referred to as relevant events anyway. Other matters that entitle the contractor to further payment for destruction caused by the event are referred to as relevant matters, and they're listed separately in the contract. Now, under the JCT, it's a principle that if an event is neither a relevant event or a relevant matter, then it will be at the contractor's risk entirely. So, given the importance of the extension of time provisions for the allocation of risk between the contractor and employer, or contractor and subcontractor, and the potential consequences of the extension of time provisions, so listing what are the relevant matters under the contract, failing to include certain events that potentially, well, failing to include actions by the employer that prevent the progress of the work, putting time at large. The interpretation of extension of time clauses is very important. I've highlighted here the Percy Bilton decision of the House of Lords in 1982. Where it was held that the withdrawal of nominated subcontractor was not the fault of the employer in the absence of a contractual provision entitling the contractor to an extension of time. The contractor was not permitted to claim an extension to the completion date. This case is often cited as an authority for the proposition that if a contract contains no express power to extend time for a delay, which is not the fault of the employer, the contractor assumes the risk for that delay. So when thinking of the time obligation, that is the obligation to complete by the completion date agreed under the contract, it's obviously important that the contract is clear about when exactly the work has been completed. So up to what point is it that, up to what stage of the works is it that the time obligation is achieved? And the way that the standard forms of contract deal with this typically is with reference to practical completion, which I'm sure many of you will be familiar with. And this is once the works reach a certain stage of completion, that typically in inspections carried out by the contract administrator or architect. And they certify either that the works are practically complete, or otherwise they will provide a list of what needs to be done for practical completion to be certified. But the certification of practical completion is of huge significance to the contractor and the employer, not least for insurance purposes, for the release of the first motive of retention, for the passing of risk from the contractor for the site to the employer, and for the levying of liquidated damages. Now, when does practical completion occur? This is often an area of dispute. Most tribunals will take a pragmatic view. Careful consideration needs to be given to the wording of different contracts, some referring to substantial completion, practical completion, sectional completion of different parts. As discussed in the recent case of Mears and Cost Plan, which I was involved in last year, the state of practical completion is often easier to recognise than it is to define. But in broad terms, Coulson summarises as a state of affairs in which the works have been completed free from patent defects, other than ones that can be ignored as trifling. I suppose that sort of falls in the category of answer of, how long's a piece of string? Twice the length from the centre. It's not a it's not a straightforward question to give answers, and it's fact sensitive depending on the type of project. So notices and condition precedents and extension of time provisions. This is an area which I see an awful lot of argument about, and see an awful lot of contractors who are feeling rather hard done by about notice provisions that are contained in the extension of time clause. Now, it is very common for contracts to include conditions precedent on contractors' entitlement to claim an extension of time. And this might be a strict time limit. It might be making reference to a provision of a notice as soon as practicable and no later than when the contractor should have become aware of the delay event. What these clauses seek to do is, I suppose, from the employer's perspective, give them a degree of certainty about how delay events must be dealt with by the contractor and what happens if the contractor doesn't deal with them as and when they arise during the works. And so it can be seen that these sorts of limitations prevent a situation where delay is being dealt with in one huge morass of argument at the final account stage, when really these should have been dealt with as and when the issues were arising between the contractor and the contract administrator or project manager. As mentioned, extension of time provision, condition precedents are often brought in under schedules of amendments. And when I say a condition precedent, I mean generally a notice provision which is a requirement for the contractor to establish any entitlement at all. Courts have recently shown reluctance to interfere at all with clearly drafted conditions precedent clauses if the requirements set out are clear in the contract. Now, it's not unusual to see what look like quite onerous condition precedent clauses which claim to prevent the contractor having any entitlement to claim any extension of time if notice is not put in within a very, very short amount of time of them becoming reasonably aware or of an instruction by an employer or a contractor. But I think it's only going to be in very dramatic circumstances and where the terms are hugely onerous would the court even consider trying to say the deal struck between the parties is unenforceable. So compliance with procedural requirements is very important. So two cases here on what a condition precedent for an extension of time entitlement needs to include. Sternia was an important decision as it rode back on an earlier case with a long German name which escapes me now. But what this said is that the condition precedent clause, it doesn't need to spell out all the consequences of a notice not being put in. It just needs to be sufficiently clear and mandatory. So it doesn't need to be long, and it doesn't need to tell the contractor exactly what's going to happen if the notice is not put in. A more generous view was taken in the Swadling case, which is 6 years ago now, and this was a huge dispute concerning a tunnel under a runway in Gibraltar, which is rock and roll. Okay, so how is the delay effect of relevant matters or compensation events assessed? Under the JCT, and this is an important point, the effect of a relevant matter is assessed based on the delay that relevant matter causes to the completion date or sectional completion date. What does this mean? Well, it means that a relevant matter might occur, something that causes delay, but if that delay is not critical to the completion date, so the works can be moved around in such a way that there's some float in the program for that particular activity that's been affected, then there is no entitlement to an extension of time. There may well be an entitlement to loss and expense for disruption. So you'd be looking at that under section 4 of the JCT. But the only thing that's important is delay to the completion date. Brief mention on the NEC under clause 63.3. A delay to the completion date is assessed as the length of time that, due to the compensation event, planned completion is later than planned completion as shown on the accepted program. Effectively the same thing. We're only really looking at delay to the completion date, and that is why having a program at the outset which shows the logic of the work and then updating that program as the works progress, showing how it has been actually built relative to how it was originally planned and what events have caused delay during the course of the works, is important. It's the process is all about showing the effect of relevant events on the critical part of the works, so that the event in question is actually impacting on when the completion date can be achieved by the contractor. So quick note on program. Generally, well, certainly under the JCT form, the program is not a contractual document. It's a management tool. It's planning of the work at the outset. It's for monitoring the progress of the works, and it can play a very important part if seeking to obtain an extension of time or claim for loss and expense. So it can be a significant practical use, but under the JCT form, it's not. It doesn't impose obligations in and of itself generally, unless incorporated by amendment. But as many of you will perhaps be familiar, the NEC takes a different approach and has a contractual program. And this is a program document that requires updating and is used as the document to the contract to establish entitlement, and so plays a central role. So, quick review of elements of a claim for an extension of time and delay analysis. So when looking at a delay event, how should we think about this? How should the claim be presented? Well, the following questions are good places to start. First, we're looking at what was supposed to happen. How were the works supposed to be carried out? What was the original program? What was the logic of that program? Could that program have been performed by the contractor but for the relevant event? Then we're looking at what things have happened that have impacted on the program that the contractor would have performed but for what it's claiming are the relevant events, and looking at the cause of the differences. So how did events affect the program? And then we're looking at who is responsible for those events under the contract. What's the allocation of those risks under what's been agreed between the contractor and employer, or contractor and subcontractor? And I've highlighted here that there are probably 3 different types of delay on a construction project. There are the ones where the contractor assumes the risk for cost and time consequences of delay. So perhaps this would apply most commonly to matters that cause delay which are within the contractor's control, such as its ability to source labour, its ability to source materials. And so those are delay events where the contractor needs to bear the cost and the time consequences of not completing on time. The second type of delay is where the contractor is entitled to its cost and time extension as a result of the issue that's caused delay and disruption to the works. So these are the employer risk events. So typically these are the caused by the delay events that are within the employer's control, i.e. when it gives the contractor access to site, if it instructs any variations to the works. These are things which would typically entitle a contractor to more time and more money, provided they're making those claims properly under the contract. And third of all, there are the neutral events. So these are events which neither party is held to bear the risk, and the contractor has an entitlement to time, so it's a relevant event, but not money, so it's not a relevant matter. And I suppose a recent important examples, well, recent issues that people have been looking into are force majeure clauses under the extension of time provisions in contracts, and provisions that provide for how a contractor is entitled to extra time in the event of government interference, the government intervening to prevent work. These are typically events that are neutral, give the contractor more time but no money. How does the contractor establish an entitlement to an extension of time? As mentioned, the extension time provisions allocate the risk of delay events between the parties. I would thoroughly recommend anyone facing these sorts of issues to give the SCL protocol, which you'll be able to find on the SCL's website, a look, as it provides thorough guidance on best practice in presenting an extension of time claim, and it's a long and detailed document, but it's received, well, it's been accepted by the courts as a guide to best practice. These are the things that you need to be establishing anyway with your extension of time claim, whether that be after serving a notice in your particulars of the delay, or if the requirement is prospective in the such as under the NEC form contract, it will follow the same format, and it will follow the same format if there is a full-on dispute about what the contractor's entitlement is to the extension of time. It's primarily a matter of proving facts. So first of all, the contractor, to claim an extension of time, must establish its entitlement under the relevant extension of time provision. So what is the event, and why is that event a relevant event, entitling it to extra time? Careful consideration of the wording of the extension of time provisions is warranted at this point, but that's the first thing you're setting out. You're saying this is what's happened and it's a relevant event for this reason. Second, the contractor must demonstrate that the relevant event has actually caused delay to the completion date for the works. So there needs to be a process of proving that, as a matter of fact, delay has been caused to the work, and this is often a difficult process, and it's where delay analysis techniques will be brought in. So you're discussing what caused the delay event in order to establish the entitlement to the extension of time, and then the contractor after that needs to prove what the effects of the irrelevant event are in terms of completion of the works. Again, this is a matter of proving facts, and this will almost invariably be based on site records that have been maintained whilst the works are being carried out. Fourth, the contractor after that must be able to demonstrate what they have done in order to prevent delay. The contractor, irrespective of anything else, will have a general obligation to mitigate the effect of a delay event in common law. However, contracts also impose stricter obligations often on contractors to take special measures to prevent delay. Now, if a contractor has been affected by a delay event that is at the employer's risk, its entitlement will only be to the extent that it can show that it has incurred delay despite taking whatever measures were reasonable to mitigate that delay in so far as possible. And I refer there to the standard JCT requirement. So in your particulars of delay or in your referral to adjudication, you will want to be pointing to the things that you have done to show that you have done whatever you reasonably could to mitigate the effect of the relevant event. And fifth, I've included this separately, but it really encompasses all the previous points. It's for the contractor to produce evidence to substantiate the truth of its submissions and the cause of the delaying event and its effects. This is often the most significant challenge, and the position of the contractor will often be determined by the quality of the evidence it can produce to show that the effects of the relevant event on the completion date, and that site records are of paramount importance for these types of claims. I suppose that probably goes without saying. I mean, interesting looking at the Arcadis's recent global construction disputes report. The number one cause of disputes between contractors and employers that it highlights are unsubstantiated claims and misunderstanding on the part of contractors and employers about what the obligations are that are imposed by the contract. So it's vital for contractors to properly set out the facts in their particulars that they're submitting under the terms of the contract or otherwise in their referral to adjudication, and that those facts be substantiated in the event that they are challenged. And special consideration needs to be given to the fact that if this is a dispute that's being referred to adjudication, then the adjudicator will be coming at this completely cold. They don't know the background to the works. They don't know about all the things that have been going on on site, and the contractor, by referring a claim requesting an extension of time due to a dispute, carries the burden to prove its entitlement. The employer does not need to prove that the contractor is not entitled to anything or the contractor's claim is wrong. It can leave it to the contractor to present what it likes and allow the adjudicator to make a decision based on it. But if there is not good evidence presented, then you're asking the adjudicator to do an awful lot. And really the analysis all starts with the account of the relevant facts. So that said, the claim for the extension of time, the burden on the contractor is only proving its entitlement on a more likely than not basis. So on the balance of probabilities. This doesn't mean that you need to prove every fact. You just got to show that the facts presented in the claim for the extension of time are more likely than not true. The best form of evidence is contemporaneous site evidence and records, so site diaries, timesheets, email correspondence, all of these sorts of things are of vital importance. And on top of that, I mean, recently I've been advising clients if they can put cameras on sites just to show how the work's progressing, because that sort of contemporaneous evidence can be really very useful to show what the pinch points in the project were. The contract administrator and adjudicator will primarily look at the contemporaneous evidence to establish what the cause of the delay was and what its effects are. And contractors would be well advised to deal with claims for extension of the times whilst events are still fresh in the mind, rather than leaving them to be resolved right at the end of the project, which is often a situation I'm faced with when being asked to resolve disputes concerning delay. And that's really what the NEC contract is trying to achieve. And this final point, expert delay analysis, I think there's often confusion about what role that plays. Expert delay analysis can be a very useful tool, but the significance of it, of the findings of a delay analyst will only be as strong and persuasive as the material that the delay analyst is fed. So there's not much point getting hung up about different delay analysis techniques if there isn't good site records to demonstrate the underlying facts and the cause and effect, which is fundamental to any claim for an entitlement to an extension of time. Evidence of delay, these are points that I've already discussed. Site records, obviously going to be key. Send things by email. When issues arise, make sure that notices and there's discussion on these points with relevant parties. Progress reporting and updating of programs. I mean, much of this will be very familiar territory to an awful lot of you, and a challenge that I think any contractor faces is finding time to produce an evidence trail to substantiate claims which may not even have been anticipated at the time that that issues were arising and people are on site just trying to get problems sorted out. But obviously, if processes can be put in place to secure this sort of evidence, I mean, particularly in the current circumstances where there is such widespread disruption on construction projects, then you'll be in a much stronger position and you're far less likely to find yourself in an having to refer a claim to adjudication. These are different delay analysis methods. As matters stand at the moment, the court does not say one method is, as a matter of fact, better than the other. I mean, whether or not certain types of analysis can be carried out will completely depend on what materials are available and what can be provided by the contractor to show its entitlement. So, yeah, no straightforward answer, as each principle relies on the information available in the intended budget. So, I think I might have some questions now, but that was the main content I intended to get through.
Indeed, and thank you for that, Jack. Someone's asking, can you please elaborate on the definition of causation in relation to proving delay and EOT?
Yeah, sure. I mean, causation is going to be a matter of, well, the common law test. So it's effectively a but-for test. So if this hadn't happened, what would have happened instead? And that is obviously a difficulty of analysis, is that you're comparing it to a hypothetical reality where certain circumstances hadn't arisen. But that is the question that the contract administrator should be answering, and that's the question that the adjudicator should be addressing. And if you can frame your emails on that basis, when you're saying, oh, look, if this hadn't happened, then this wouldn't have happened, and this wouldn't have happened, and so we would have been able to do this, then that can certainly help in the production of evidence as works are ongoing. And that's effectively what a contractor needs to do in order to establish an entitlement after the event if there's a dispute.
Okay, another question here. If a variation or change is a cause of delay, can you argue it is a relevant matter, but not, sorry, it's a relevant event, but not a relevant matter, i.e. agree to grant the contractor additional time, but no money if it's determined that the cause of the delay should not cost them any more money?
Yes. I mean, it's going to be subject to contract. Now, for a variation instruction, if you're using a standard form of contract, a JCT form by the sounds of it, if you're using the relevant event, relevant matter language, then the valuation of the variation is going to be dealt with under Section 5 separately to the disruption effect. Now, if you were to have the disruption effect under Section 4 of the contract, saying that no variation event would entitle the contractor to payment of additional money due to loss and expense, then I mean that might well be enforceable. However, if you're going to, you will very likely need to have it as a relevant event, so a time event, because otherwise you risk the court concluding that, or the adjudicator concluding that the contract does not make provision for an employer delay or a cause of delay affected by the employer. So the variation instruction is an act of prevention that will put time at large. But yes, I mean it's subject to contract, and the courts have taken a pretty steadfast approach in enforcing what's been agreed by the parties, and will only intervene in very exceptional circumstances.
Okay, you've spoken about the best method of proving delays based on facts, site records of what actually happened on site, instead of proving delay through delay analysis techniques such as time impact as planned, blah blah. Effectively, which method of delay analysis takes precedent over another in reference to case law?
Well, just to clarify, I'm not saying I mean delay analysis has a very important role to play, and is vital in complex projects, because the effect of individual compensation events, relevant events, is very difficult to pick apart. There could be thousands of different operations going on a site at any one time, and so without some full basis of analysis and without expert evidence being prepared by someone who should have a good detailed technical understanding on how certain sorts of works need to be carried out, it's going to be very difficult to establish an entitlement. So it's delay analysis is going to be vital within certain types of dispute. There's no question about that. The point that I was looking to make was merely that the delay analysis is only going to be as useful and is only going to be as persuasive as the information and evidence is able to demonstrate the entitlement, demonstrate cause, demonstrate effect, and demonstrate mitigation. And you know, if you feed rubbish in, you're going to get rubbish back. And if you don't have the material, then you're left in a situation where the delay analyst has little option but to take an original program, move the charts around a bit to try and show what the likely effect of things are, and it all becomes a bit hypothetical. In terms of the approach of the courts, there's a distinction between the prospective delay assessment that needs to be carried out on, say, an NEC contract. So looking forward, compensation event occurs, and the contractor needs to be giving early warning and making its claim for the extension of time based on its assessment on what effect that compensation event is going to have on the progress of the work, and the project manager is then making that assessment looking forward. So there is that prospective approach, or there's the retrospective approach. So once the works are being carried out, then you're arguing back to what the effects are of, say, under a JCT contract, the relevant event on the completion date. In terms of delay analysis techniques, the courts have shown a preference, if works have been completed, to accept delay analysis on a retrospective basis rather than on a prospective basis, because obviously by the time it's reached the court, the project's been completed. I've got a quote here. This is in Northern Ireland Housing Executive and Healthy Buildings Ireland, and this is a 2017 decision where the court adopted a retrospective analysis despite the parties' NEC3 contract catering only for prospective assessment. And the judge in that case, well, famously said, "Why should I shut my eyes and grope in the dark when the material is available to show what work they actually did and how much it cost them?" So the method of delay analysis, what is most appropriate and what is suitable will depend on the quality of the records that you have. Say under the first edition of the SCL protocol, the SCL favoured impact analysis, but the second edition of the protocol is expressed that there is no longer a preferred methodology. Instead, it just lists factors that would be significant to the selection of the methodology of delay analysis by the contractor in whatever situation. So, I mean, these are often issues that a delay analyst would be best placed to be answering once they have some idea of what site records are available.
Okay. Someone else is asking, as the minor works contract doesn't have the same relevant event and relevant matter clauses, how would a contract administrator grant an EOT for something like COVID-19 when it's not a variation?
Okay, so I mean, in those circumstances, the delay, the minor works contract does contain extension of time provisions, but not to the same detail as, say, the standard building contract. How would the contract administrator make an award? Well, you're going to be explaining again why you have the entitlement under the terms of the contract, and you're going to be framing it in terms of what effects the COVID-19 pandemic has had, and why it is a relevant event, or why it fulfills the category that the minor works contract provides for. So, I mean, in the current circumstances, the effects on there has plainly been significant effects on the labour and material supplies, constraints on border movement, so for labour coming into the country and for materials coming into the country, constraints upon the work itself, social distancing measures, cleaning requirements. These are matters that could be argued to be issues that fall within the category of force majeure. You could potentially argue that these are matters that have been ordered by the government. They're outside of the control of the contractor, and fulfill that category of being a relevant event. But I think the important point to drive home here is that COVID-19 is not in and of itself a relevant event. And the process of establishing entitlement, proving cause and effect, proving mitigation will still be vital. You know, and for a lot of contractors will warrant the development of a strategy for actually how they can go about establishing these claims. You know, if perhaps maintaining a live document that's updated on a regular basis, recording things like the constraints that have been imposed on the works as a result of issues arising from the pandemic, and the measures that are being taken in order to address those issues. This could be useful, but you know, there are problems that are presented by COVID-19 that, you know, might not be seen as relevant events at all. You know, hand washing measures, social distancing. Well, you know, is it going to be a problem typically for operatives on site to be staying 2 meters apart? Is that really what's caused critical delay? I'm afraid that the situation is far from straightforward there.
Okay. Someone else is asking here, what happens if the delay analysis proves delay against the original program, but the original program was flawed?
Well, it's going to depend on what the status of the program is. Like I've said, for the majority of building projects in the UK, I mean, engineering projects slightly different, but the majority of building projects, the program doesn't have contractual status. It just shows the intention and the plan of the contractor to be carrying out the work. And so if the works happen to be carried out of sequence with the program in that sort of a situation, then the original program, it might be said, is of little assistance to the delay analyst at all. I mean, if that's, you know, being carried out of sequence, not due to relevant events or compensation events that impact on the completion date. And so, I mean, this really goes back to the point why it's important to be updating programs, to actually be showing at regular intervals. I mean, monthly would be nice, how the work is actually being built relative to what the original program showed, or how the original program showed it would be built. I mean, the situation is slightly different under the NEC because of the vital contractual role it plays, and so really the program would need to be updated on a regular basis in order to satisfy the provisions of the contract and for the contractor to have any entitlement potentially for any of the delays that have been caused by either matters outside its control or the employer. But I'm not sure I really answered your question, but look, happy to pick up on any points if you want to email me at all.
Okay, and we've just got the one last question here. Can you provide a quick definition on concurrent delays and expand on the but-for test and or establishing the dominant cause?
Yes, certainly. Okay, so I mean the concurrent delay. I mean, this is not an issue I touched on in my slides, merely because it's an area where people have written large chunks of books on it, and it often is an issue that's brought up where perhaps it's more of a distraction than a real issue.
Yeah, we have got several seminars on it, and what I'll do, I'll send the person who asked his question a link to those later, so they can have a full.
But needless to say, it's a complex area. I mean, this is Hamblin in Adyard, Abu Dhabi, He said a useful working definition of concurrent delay in this context is a period of project overrun which is caused by two or more effective causes of delay which are of approximate equal causative potency. So there's an overlap of two things that are causing delay at the same time. Say, take an example. A contractor delay, they can't get the men to start the job on the commencement date, and an employer delay, the employer couldn't give access to the site at the same time. And so there's two causes of delay, one which the contractor bears the risk for, one that the employer bears the risk for, that overlap each other. And I mean, Henry Boot Malmaison is still the I suppose the guiding light as to what the effective concurrent delay is, although again this has been subject to a lot of criticism and an awful lot of writing, and that's that the contractor would be entitled to time but not money as a result of its liability for the contractor delay event in circumstances of true concurrency. But you know, for concurrency, as indicated in the name, these need to be happening at the same time on the program, and from experience, it's an issue that I see thrown up an awful lot more than I actually see it sticking. But yeah, for the working definition, I don't think you can do better than Hamlet.
Okay, and then there's just one last one that's just come in. Someone's agreeing with you that under the JCT, the program is not a contractual tool; it's only an indication. Their question is, why do EAs and CAs rely on it for awarding EOT?
I suppose it's because it's the best guide that they've got. And because when discussing an entitlement to, well, when analysing an entitlement to an extension of time, there is no way of getting around the need to work out the logic of the works. So what work needs to be completed before what bit of work can be carried out. So, you know, how the critical path flows. And I think from the perspective of a contract administrator who has received a program from a contractor at the outset showing how it intends to carry out the work and complete it by the completion date, and showing the logic of its work process, that the program is really going to be its best guide for how the contractor has either been impacted by events that are at the risk of the employer, so things like variation instructions, acts of prevention, that sort of thing, or otherwise, what other issues have there been on the contractor's side that have actually caused the delay. And it's a useful starting point, because it can be analysed on a monthly basis. If you have groundworks taking in your program 6 weeks and they've not been completed after 2 months, and you know there's no apparent cause of delay, then you'd be thinking, well, that demonstrates the fact that this delay is the responsibility of the contractor for not getting the work done. I don't know, maybe it's been under-resourced, maybe they've had their own problems, but those are things at their risk. And then that's why they would be looking to use it, because you've got to, all claims for an extension of time will hinge on the actual logic of the works and how it needs to be completed. And so if the original program is wrong, you know, it's incumbent, and that program doesn't have a contractual status, it's incumbent on the contractor to update it and to say, well, this is actually, you know, this is our correction and this is how we're going to achieve the completion date instead. And this is as built as it's going up.
Okay, that's great. Well, thank you, Jack. You've answered all those questions. There were a fair few of those in the end. So thank you for your time. Thank you everyone for attending, and hope everyone is continuing to stay safe and well. And we will see you online again soon. So thanks, Jack. Thanks everyone else. See you soon.
Thank you.